Good morning, everyone. I'm Yolanda Nodendwa, working for Biosecurity Issuing Authority in Cape Town, and I'm going to take you through to the permitting process for invasive species in South Africa. The presentation has been derived mostly from the most frequently asked questions that we've received from the public. Research institutions, all our stakeholders. Okay, basically going to highlight or outline the AIS regulations, the permitting process, the permitting fees, which species that you need to apply permit for, which people need to apply for permits, the different platforms where you can get our permits, the different platforms where you can contact us. So, the alien invasive species were first published in 2014, and they were amended in 2020 and came into effect again in 2021. And the reason for these alien invasive regulations is to regulate the import of invasive species into South Africa, as well as also to regulate the invasive species within the country. We currently have 118 Category 2 species that people can apply permit for, and we also have we can also apply permits for importing species into South Africa. The issuing authority, or why are permits issued? We issue permits for different restricted activities. These are outlined as possession, for transporting, for selling, for breeding, for imports, for aquaculture, all the spheres. And we also issue permits for research purposes. These are the outlines, restricted activities, and the categories that each restricted activities is listed under. If you would see mostly for Category 1A and 1B and Category 3, most of the restricted activities are prohibited, but for those listed under Category 2, permit is required, and in some instances they are exempted. And this is just a follow-up of the other restricted activities that you can apply permits for. This is just giving you a total list of the species under Category 2, which amount to 118 for the different taxa where permits can be sought for. And then we have the risk assessments that must accompany each application. So we've broken it down since the last regulations. We've broken it down into two sections. The first risk assessment would be the comprehensive one, which would include the importing or new introductions, also for breeding and convey and possession. And then there's a smaller version of it, which is under 16.5 of the regulations, which only covers the possession of a species, and that can be done by the applicant. The first risk assessment needs to be conducted by a certified risk assessment facilitator. They need to comply with SACNAFs. They need to have background of the subject. They need to have background of the invasive species, etc. When it comes to introduction or sorting out of permits for introduction of new species into South Africa, a different process is followed other than the one for species within South Africa. It includes informing our stakeholders, includes informing or getting ASRAP, which is our risk assessment panel based in SANB, who will review the risk assessment and assist the department in arriving at a decision to issue or not issue the permit. And then For species that are already in the country, a different process is followed. We still continue with engaging our stakeholders, our provinces, also our research institutions, but then the internal decision only involves the issuing authority. The following slide is just a breakdown of the permits and permits that have been issued in the Western Cape, particularly in the 2021-2022 financial year. And if you can see the list of the species that we mostly get permit applications for, plants in the Western Cape are leading the pack, with fish and birds and reptiles and mammals. And then the following slide is just the application fees that you need to submit with your application form. They vary from imports and the other restricted activities, including renewals and appeals. Thank you.
Fantastic, Yolanda. Right, we must have some questions with regards to species.
Ronelle Clark from City of Cape Town. Yolanda, thank you. Could you go back to your third slide? I'm just curious to understand the difference in notice 1. I think it was the one before that. Notice 1. There we go. I see category 1A, 1B, and 2 are exempt if you have in possession. But I'm curious to know the difference between that and growing, because if you have in possession, does that then mean that the plant is dead versus growing, which is prohibited in your third row? Does that make sense?
But it would be exempted if you already have it in your possession. So if it's already in your property...
Not growing, in other words, dead. It would be dead.
It would be?
It would be dead? The plant would not be growing, in other words?
No, it wouldn't be growing. It wouldn't be dead, but you'd be exempted because it's already on your property.
Okay, so you're allowed to have it in your garden.
Yes, but you're not allowed to do anything else with it.
Okay.
We've got another colleague which was going to answer that question for you.
Thank you. I'm Libuani Nzeru from the Department of Forestry, Fisheries and the Environment. I work with Yolanda. So regarding your question, what Yolanda has indicated is correct. But if you look at that restricted activity, it talks about growing, breeding, or any other way of propagating the species. So if you are in possession of a plant which is just growing within your property, so it means you will be exempted. But if you are going to plant the seeds or you cut part of that plant and decide to put it on the ground to grow, that's the part which is prohibited. Thank you.
It doesn't mean that the plant is exempt from being taken out or removed. It's just from the permitting. Does that answer the question?
Risk assessors, assessors, where do you get that? Because you talked about they need to have this and all that, because I know with us in particular, there's some trials or research that we want to do, and to do such risk assessments, you need the risk assessors that you're talking about, and also with submitting a risk assessment with whatever activity for a plant or an animal, the time frames that go with that, and who gets to approve those activities for a plant species or for an animal species. I don't know if you are.
We've always gotten questions about recommended risk assessment facilitators, but we're not in a position to say this is the person that you can go to. But we have the list from SACNAS of the registered risk assessment facilitators that we can recommend to you. But for a private risk assessment facilitator, we're not in a position to say go to this person. Does that help? Okay.
Great.
The CARA legislation, the NEMA legislation on these alien regulations, what is the status of CARA? Is it still applicable? And how do we have to manage them both now? applications in terms of applications?
Well, I know the NEMA regulations are the ones that are working now. So in terms of CARA, no, they've fallen away, right? Or they still, my colleague says CARA is still working, but I know with invasive species, for alien species, you can still contact our office. But we don't force you not to comply with any other legislation. You're still allowed to comply with any other legislation.
If I do an application in terms of the regulation, that's fine. I don't have to do the car legislation application
No, what I'm saying is you still have to comply with us, but any other regulation that you still need to comply with, you need to. Yeah.
Great.
Good morning. My name is Llewellyn Erasmus, Department of Agriculture, Land and Rural Development. My question is, what is the time frame for an applicant to apply for a permit, and what is the turnaround strategy for the permit deadline, meaning the execution date? How long is it valid for? Thank you.
Okay. Our permit turnaround time is usually 30 days if you have every document in place, but we also allow it to up to a process of 60 working days for us to process your application, do our inspections, go out in the field, do the recommendations, and then issue the permit. So for us, a turnaround time, it's up to 60 working days. So immediately when our compliance officers maybe visit your facility, within that time frame that they specified, apply for your permit, and then our turnaround time will be a maximum up to 60 working days.
Great. Fantastic. Question from this gentleman?
Good morning. My name is Tebe. I just want to ask, how often do you update your alien species management plan, if you have? I'm from the mining industry, and we have alien species management from a specialist. So how often can I update that, get a new one?
Okay. A species management plan will be covered under compliances section. Okay.
We're going to deal with that under compliance now, and I think your question will be answered. Do we have any more questions for Yolanda, gentleman over here?
It's Tom Robbins from the Botanical Society, Kirstenbosch branch. I don't know if this is the right place to ask the question, but for example, if you have a category 2 alien, which is exempted, and the state or private landowner is allowed to have that plant on the land, and the people responsible are not propagating it or whatever, but there is spread of the species, natural spread of the species, because it is an invasive species, and it spreads throughout the property and beyond into neighboring areas. What is the situation there?
I'd like to answer that. Dr. Guy Preston always used to use this wonderful term called duty of care. So it's ultimately the landowner's responsibility, if something falls into that category, to control it. That is his duty. And if it is a category, as we've seen now, species which requires permitting, it requires it irrespectively. So the onus is on the property owner to ensure that that doesn't spread and it is controlled. I hope that answers your question. Okay. Yeah, but it still requires a permit, irrespective.
But if it's spreading, I mean, I don't know if it's just because of being under-resourced or...
Yeah, but if you have a situation where the plant is spreading and it doesn't have a... if you don't have a permit, then you're in contravention of not having a permit for that plant. And if you have the permit, then it is part of the management plan that you submit to ensure that you have the controls to stop it from spreading. Does that make sense?
Yeah, but I mean, in reality, this does not happen.
Well, I think that's what we're here today, because we need to get closer and closer to that point.